consider, again, a personal recognizance bond for Mr. Terry now that he has pled to a single misdemeanor. He does now have reliable transportation to court in the form of his mother and his own transportation. He has a job at tradesman that he could go back to. Again, he did admit that he had a slip up with regards to his sobriety, but he is committed to doing better. He's provided proof that he was enrolled in medically assisted treatment as well as mental health services through Packard Health and CMH prior to going into custody. And he had already completed an access interview with Home of New Visions and had planned to enroll in intensive outpatient treatment, again, prior to the bond violation, and would plan to do that if released, if Your Honor, again, would consider a personal recognizance bond.
So there's no plan set up for what he's going to do at this point? There is.
It's my understanding that he was approved to participate in intensive outpatient through Home of New Visions. He would just need to contact them after he is released.
Anything from the people?
Your Honor, Mr. Terry has been able to provide through his counsel a proof of the treatment that he's been undergoing since February or March of this year. So we would leave it up to the court's discretion since he is.
Well, I'll tell you what, I'm going to deny at this point, but the reason my understanding is you would be shortly seen by 1482's probation. And certainly that can be then addressed by Judge Bars to his release. All right, consistent with what they see. So at this time, I'll deny your motion for bond modification. Bond will continue.
Thank you, Your Honor.
All right. Thank you, sir. Good luck to you.
Sure, thank you.
Court calls the case, People versus... Is it? You have Asher. No. What about, do you have Huffman? Court calls the case, People versus Orby Huffman.
AP Richmond Deputy.
Your name, sir?
Orby Huffman.
It says Mr. Brown is the attorney.
Is represented by Mr. Burgess. Mr. Burgess is a substitute.
That is not what, when did that happen? This morning?
I want to tell you yesterday.
So where is Mr. Burgess?
He's not here.
We'll have to stand in that for adjournment, Your Honor.
New counsel coming in. All right. Sir, I don't have the public defender had to withdraw from your case. I don't know if they discussed that with you or not.
No, they did not.
Okay. The reasons, there's a conflict of interest. It looks like because of the public defender's representation or prior representation of the complaining witness in this case. Okay. So they would have to withdraw. They've withdrawn. The appointing authority has appointed Mr. David Burgess to represent you. Okay, we have not heard from Mr. Burgess this morning. Don't know where he is. Quite frankly, even if he appeared today, he probably wouldn't have everything to be able to and have talked to you to make an intelligent decision as to what to do with it. Okay. And so he'd likely asking for an adjournment anyway. So what I'm going to do, that's a long way of telling you, I'm going to adjourn your case out 1 week. Make sure Mr. Burgess has everything that he needs and then he has the opportunity to come talk to us. Okay? Probable cause conference will be adjourned 1 week to July 10th, 2025, 9 a.m. Bond will continue. Thank you, sir. Court calls the case People versus Tariq Wilson.
For the people.
Morning, Your Honor. Andrea Stammer requesting permission to practice pursuant to MCR 8.120 under the supervision of Assistant Public Defender Chinaza Akiri Ekenroli.
Is this the only thing she gave you today?
It's a
What?
list,
Really?
Your Honor.
It's the only thing she gave you?
Yeah. So far.
She's just been wandering around back there, like lost. And you didn't give her anything? Okay, fine. Anyway, your client's not here because he's not behaving himself and the facility would not sign in. Okay,
That's correct, Your Honor. At this time, we are requesting an adjournment for negotiation purposes.
okay, very good. Conference will be adjourned to the 17th, 2025 at 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. One case, really, Chanel? One case. One case. Court recalls case People versus Thomas Basher.
Austin Gilbase on behalf of Mr. Thomas Vasher, who is present to my right, Your Honor. Mr. Vasher, can you state your name for the record one more time?
Thomas Bashan.
Standing is that the defendant will be pleading guilty to count 2, the receipt and concealment of stolen property less than 200, which is a misdemeanor punishable by up to 93 days in jail. Upon a successful plea to that charge, count 1 would be dismissed.
That is a correct reflection, Your Honor.
May I have it sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Thomas Bashan.
So it is this court's understanding that you are going to be pleading guilty or no contest to the charge. No contest to the charge of receipt and concealment of stolen property less than $200.
Yes, Your Honor.
All right. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court.
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. First thing is it means that you're not further desirous or wanting to contest this charge.
Yes, Your Honor.
Second thing is that for purposes of sentencing, the court would treat you the same as though you had pled guilty.
Yes, Your Honor.
Basis for the no contest plea?
Potential civil liability, Your Honor.
So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights? Look at paragraph 5.
When the phone starts recording, people reveal who they really are. Victims get louder, aggressors get bold, and bystanders suddenly vanish. Cameras don't just capture the truth, they corner it.
Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No. Not that I-
Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No,
Has anybody threatened you or coerced you in any way?
no, Your Honor.
You're doing this voluntarily
Yes.
of your own free will.
Yes, Your Honor.
All right. Court has been handed and has been provided and has reviewed Washtenaw County Sheriff's Office report for their case number 255214. Any objection to the court having reviewed that report?
No, no objections, Your Honor.
Sir, I do have to advise you that any sentence evaluation and or agreement regarding your case, if you were to commit misconduct from the time I accept your plea to the time of your sentencing, that the court would not be bound by that. You understand that?
Yes, Your Honor.
You understand also that if you commit that misconduct, you would not be entitled to withdraw your plea.
Yes, Your Honor.
You understand that, sir? All right. Counsel, based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Is counsel aware of any other promises, threats, or inducements which caused this plea?
None, Your Honor.
Has the court complied with the court rule and would it be proper to accept this defendant's plea?
The defense is satisfied as well, Your Honor.
Court will accept the defendant's plea of no contest to this charge. To count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing in this matter will be
July 1st, 2025 at 10 a.m.
July 31st, 2025, 10 a.m. That is before Judge Washington.
Here, may I address bond when appropriate?
If you want to, go ahead.
Your Honor, now that my client has dealt with this case, the only other case that we'd be holding him is a driving without a license case out of
What?
Now that my client has dealt with this plea and the felony was dismissed, my client is asking to be released on a PR bond. The only other case that he has currently is a license case out of 14B.
And I would already given that would be reduced to the PR bond.
Yes.
If I was reinstated.
Response?
Your Honor, given that felony is now gone, I don't necessarily object to the court reconsidering bond. However, I would you have 3 pending board requests, one for fleeing third OUND in March, a RNO in April of this year, and a enforcement in the building from May of this year. At the time of this offense, the defendant was in abscond status from circuit court probation.
Your Honor, my client asked that he once again be given a PR bond. If the court deems it appropriate, he can go on a tether. He has no issue doing that. He just wants to get out, hopefully get back to his job. His girlfriend was here for support, but she
Mr.
had.
Basher, it really is not helping your cause to sit there and try to mouth anything to me. All right? Because I'm trying to listen to your attorney and not pay attention to you.
Yes, Your Honor.
He does have some support here. She was here in the court waiting for him for about 3 hours, but she had to leave. As I said, Your Honor, the only other matter that would be holding him is a driving case. And these other charges that are pending have been pending for a long time. We haven't got anything. So
Are those going to be coming forth anytime soon or what? I mean,
the APAs who are assigned to those warrants aware, and they look very chargeable to me, Your Honor.
also, Your Honor, my client has been in custody for 45 days now.
all right, I will grant the defendant's motion to modify his bond. I'll set his bond at a $10,000 personal recognizance bond. Defendant may be released on a GPS tracking tether prior, or can be released only with the GPS tracking tether in place, location tracking.
Understood, Your Honor. Thank you.
Thank you. Court does call the case People versus Virgil Dunlap.
Here, hearing on behalf of the people.
Edward Drickus for Virgil Dunlap.
Your Honor,
Please state your name.
Virgil Dunlap,
I was appointed yesterday. I obtained the written discovery. There's some outstanding video discovery that I'm going to ask for an adjournment to obtain.
Probable cause conference will be adjourned July 17, 2025, 9 a.m. Bond continued. Court does call the case People versus Elton Bell.
Zachary Ward on behalf of the people.
Kevin Datish on behalf of Mr. Bell, Your Honor.
Wow, it's been like 2 hours now since I left. Go ahead. I'll let you go.
He's answering my phone calls. He said his ride is just not answering his phone. I would like to ask for an adjournment. He literally was going to come here, make a payment for his.
You want me to send a car for him?
I can help him with that next time. He doesn't have transportation. He's relying on people who used to work for him in the past to get here. I'm even inclined to have him learn Zoom so he's able to attend, so we don't have to worry about this in the future. I don't believe he's ever not appeared before, based on my notes.
You don't know.
So we are going to be asking for an adjournment, Your Honor.
Your Honor, this is a larceny case where the defendant took a check from the victim for $2,000 and for over a year they thought around to do the work, I'll pay you back sort of thing, and here he is supposed to show up and pay some money for a misdemeanor offer and he doesn't have a ride. We haven't seen photographic proof of him not having a ride. So
I don't know what that photographic proof of somebody not having a ride would be.
Well,
Me sitting in my house?
He suggested it.
I don't know. It's a running joke.
Yes, that was.
And Your Honor, he is 65. He receives quite little. Social Security, he doesn't work, he has injuries. We're trying to provide, he was going to come with documentation of his injuries.
Are you on the docket next week?
I should be.
Okay. So what
He will
I'll
show
do is
up.
I'll adjourn it out a week. If he doesn't show up, then I take you into custody.
I'm okay with that.
You're okay?
Yeah, thank you, Your Honor.
Good.
She is good.
Sounds like she is?
Yes.
Oh, yeah. He's just like, yeah, she'll be.
Now she's gonna, even if we're off, I'll be here.
Probable cause conference, July 10th, 2025, 9 a.m. Found continued.
Thank you, Your Honor.
Mr. Dish didn't seem to care, did he?